Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. We've talked a lot about defamation law in prior videos, and that's because of some big cases that have been generating a lot of headlines, including Stormy Daniels' case against President Trump, and the case of some of the Covington Catholic high school boys, including the 16-year-old at the center of attention, Nick Sandmann, filing suits against various media personalities, media companies, and Hollywood celebrities. Now we have an interesting development in defamation law from the United States Supreme Court itself. First, a little background. A woman named Catherine Mae McKee, one of Bill Cosby's accusers, had sued Bill Cosby for defamation. Her grounds? Cosby's attorney had drafted a letter and then disseminated it to the media, which published it. She claims the letter deliberately distorts her personal background to damage her reputation for truthfulness and honesty, and further to embarrass, harass, humiliate, intimidate, and shame her. She lost in the trial court and the appellate court because those courts applied the seminal 1964 Sullivan v. New York Times decision. The trial and appellate courts held the accuser, Ms. McKee, by coming forward and accusing Bill Cosby of rape, had thrust herself to the forefront of the public controversy over sexual assault allegations implicating Cosby, and was therefore a limited purpose public figure. Because she was deemed to be a public figure, the courts applied the actual malice standard, meaning she needed to prove that Cosby wrote and published the letter with actual malice. That means she would have to prove that Cosby published the statement with knowledge that it was false or with reckless disregard of whether it was false or not. This is a very high standard for plaintiffs to prove. It prohibits public figures and those deemed to be public figures from being able to recover damages for defamation unless they can satisfy this high burden. You may recall President Trump complains from time to time about libel laws and about how he wants to liberalize them. And this is what he means. Trump claims the law does not treat public figures equally with all other Americans. It tilts the playing field and tilts it strongly against public figures, and Trump is correct. So Cosby's accuser asked the Supreme Court to hear her appeal. The court denied her request because it was based upon a factual dispute and not a legal dispute. Regrettably, it appears Ms. McKee did not challenge the constitutionality of the 1964 case Sullivan v. New York Times. If she had, she would have received a popular reception from Justice Clarence Thomas, who wrote in the concurring opinion denying her request that he wishes the courts would reconsider existing libel law. Justice Thomas heavily criticized the Sullivan v. New York Times decision and its progeny. Thomas complained that in Sullivan, the court federalized defamation law, which from the founding of this country until that decision had been a state law issue. Thomas also criticized Sullivan because it invented a new rule of law that prohibits a public official from recovering for defamatory falsehood relating to his official conduct unless he proves the statement was made with actual malice. And then later court decisions expanded public official to include public figures. And courts then expanded public figures to include private persons who thrust themselves to the forefront of particular controversies, public controversies, in order to influence the resolution of the issues involved. So now we have the odd situation in which a woman, Ms. McKee, a private citizen who was allegedly raped by Bill Cosby, which is a rather private event, is considered a public figure and thus essentially prohibited from suing Cosby for defamation because Cosby is such a public figure and his rape case became such a public event that it turned Ms. McKee, a private citizen, into a public figure. Not fair for Ms. McKee, is it? I don't think that's the way the law was ever intended to be, and neither does Justice Thomas. Justice Thomas claims none of these decisions are grounded in the Constitution and the First Amendment as originally meant by the framers of the Constitution. Thomas wrote, "The common law of libel at the time of the First and 14th Amendments were ratified did not require public figures to satisfy any kind of heightened liability standard as a condition of recovering damages. Typically, during the time of our founding, a defamed individual needed only to prove a false written publication that subjected him to hatred, contempt, or ridicule. And the law at that time even presumed general injury to reputation, so you didn't have to prove special damages. And the law at the time also presumed malice, unless there was a privilege, right, or duty involved. So Justice Thomas wrote, before our decision in New York Times, in Sullivan v. New York Times, we consistently recognized that the First Amendment did not displace the common law of libel. And as I stated earlier, Thomas wrote, we should reconsider our jurisprudence in this area. Well, that's a very good sign for those like me who believe in the original meaning and intent of the Constitution, for public figures like Donald Trump, and for people like Ms. McKee, who are obviously not public figures, but are deemed to be so by the courts, and thus barred from proceeding on a defamation suit against a public figure. If you have questions about defamation, libel, or slander, don't hesitate to give us a call at Scaringi Law. We practice in this area, and we'll try to keep you abreast of any developments and changes in libel law that might stem from Justice Thomas's concurring opinion. Well, that's all the time we have today for the Scaringi Law lunch break. I hope you learned a little bit about the law. Thanks for listening, and enjoy your lunch.